Hi class, and welcome to the Punishment and Sentencing uh, online lecture and discussion. This discussion goes hand in hand with Malakot, chapter 10. So let's go ahead and get started. This is a good link, and I have a screenshot of the video for you to watch. It's 4 minutes and 25 seconds, as you can see. It's not a long video explaining the different theories of punishment and the justifications of punishment that I will discuss in a minute, but it does go in depth into each one, so I recommend watching it. So let's go ahead and get started with the objectives. Discuss the different sentencing philosophies, compare the difference between indeterminate, determinate, and mandatory sentences, explain how federal sentencing guidelines are used, and identify the current methods of execution and legal punishment, all the way to capital punishment. So, in this chapter, or in this week online lecture, we're going to be discussing the different justifications for punishment, or the different correctional philosophies, if you will. So think about it. When you're going to punish someone, when the government or society is going to punish someone, you have to think, what is the purpose of that punishment? Is it to prevent someone from doing the same thing again, right? Or do we want to punish someone to send a message that certain behaviors will not be tolerated? So these are the five different philosophies that have helped guide our sentencing and correctional practices, and each of these philosophies has been popular at different points throughout history. And in order to understand these different practices and how they are used by the criminal justice system, um, we first have to understand their foundations. So we're going to go ahead and begin with deterrence. So deterrence suggests that offenders will be discouraged from committing crimes if they fear the punishment that the punishments that are associated with these acts, right? So you wouldn't want to do something, commit some type of crime, if you know that there's a punishment for it, right? So there's two different ways in which deterrence theory works. So first we have the concept of specific deterrence, which looks at how individual behaviors are curbed as a result of Beccaриa's pain-pleasure principle. So an individual is going to decide that the threat of punishment is undesirable and will make the decision not to engage in criminal behavior. Then there's general deterrence, and this is going to suggest that if people fear the punishment that others receive, they will decide not to engage in similar acts, as they do not want to risk the potential punishment for themselves. So, in this case, let's say I know someone who committed a crime and they got in trouble and punished for it. Um, that is going to deter myself and the rest of society from committing that crime, because I'm going to now be in fear of receiving that punishment, which will thus lead me to not engage in criminal behavior. So, um, in order for deterrence to be effective, right, the punishments must possess three specific characteristics, and the first of these characteristics is certainty. This means that offenders need to be reasonably aware that if they engage in a criminal act, they will be apprehended and punished. Consider that parents generally teach their children not to touch a sharp object, right? Something like a knife, or else they will likely get hurt. This works because as a punishment, getting hurt is relatively certain. So when it comes to crime and punishment, this level of certainty doesn't exist because crimes occur every day that are not reported to the police, and then offenders are not punished for these acts. So, second, the punishment must be severe. If the punishment is not harsh enough, offenders may not be deterred from engaging in the criminal behavior. So, the severity of punishment can limit the certainty of that punishment. Think about it. As the severity of a punishment increases, the likelihood of that punishment being implemented decreases. And then finally, the potential punishment must be swift. So this is also referred to as celerity of the punishment. So celerity of punishment references the amount of time between the criminal act and the punishment for said act. So if the punishment does not occur in a timely fashion, the deterrent effect is reduced. Therefore, the most effective punishments from the perspective of this theory of deterrence are those that are certain, severe, and swift. Now, the problem with deterrence is that punishments rarely operate in this manner. For example, most people do not engage in a crime with the expectation that they will be caught, which negates the certainty principle. And what is considered a severe punishment is a subjective concept, right? While you may think something severe, I may not. So think about it. Some offenders might feel that 6 months in jail is an extreme punishment, and other offenders may feel that it's no big deal. So that is the first justification or philosophy of punishment. And now let's continue on to rehabilitation. So the concept of rehabilitation focuses on reforming criminal behavior so that the offender does not need or want to engage in future acts of crime. And this form, or this philosophy, excuse me, was used within the prison walls not only as a way to treat prisoners and help transform behaviors, but also to assess whether offenders were prepared to return to their community. So, in this school of thought, we want offenders to leave prison better than they came in. So, um, a little bit history about it. During the 1990s, rehabilitation became less popular as a result of a belief that nothing works. So, there was an article published in 1974 titled "What Works: Questions and Answers About Prison Reform," and the author Martinson reviewed more than 200 programs, from counseling to education, and noted rather dismal results. However, he did note that these results might reflect the efficacy of the specific programs. So, with Martinson's research becoming part of the quest to reject rehabilitation in favor of a tougher approach, like I've said before, politicians did not want to be soft on crime, so support for rehabilitative programs became the equivalent of being soft on crime. So, they took a back seat. So then in, the 1988 presidential election of Michael Dukakis, he was heavily criticized by Republican candidate George H.W. Bush for his support of weekend furlough releases for convicted offenders. So this debate, centered on the case of a gentleman named Willie Horton, who was a convicted murderer. Even though he had received a sentence of life without the possibility of parole for his crime, he was still permitted to participate in the program. Unfortunately, on one occasion, this gentleman, Willie Horton, never returned from his furlough. Instead, he traveled to Maryland, where he robbed a local couple, physically assaulted the male, and raped a woman. So, as governor, Dukakis was held politically responsible for Horton's release and was declared to be soft on crime, a position that ultimately contributed to his loss in the presidential election. So, today we do have evidence that programs can work when they're targeted toward the needs of the actual offender, compared with the general approach. And when they are approved with the financial support needed, when they are provided with the financial support needed to offer them in a manageable way and have staff that are adequately trained and supportive of the rehabilitative mission. So when implemented with these, ideals in mind, rehabilitative efforts that focus on changing the way individuals think about crime and criminal behavior can actually reduce recidivism, which is when um, an inmate leaves prison and returns. So, some of the practices are probation, parole, and the juvenile justice system. Um, Within those programs, there's rehabilitative programs. Um, Again, used to assess whether offenders were prepared to return to the community. And what I discussed earlier, that there is evidence supporting that the programs can work with adequate financial support and staff being trained. Let's go on into incapacitation. So, incapacitation is going to refer to the practice of removing offenders from society so that they will not engage in criminal behaviors for a certain period of time. So you just remove them from where they could commit crimes, and they're no longer able to commit those crimes. So generally speaking, when we think of the prison as a way to incapacitate offenders, however, technology has made it possible to utilize some of the features of incapacitation in other settings. So this is particularly useful given the current issue of overcrowding in prisons. So for example, few celebrity cases such as the one you learn about, in the beginning of this chapter when you read it, um, led to time, behind bars. So the concept of incapacitation has been used for low-level offenders as well as serious offenders. Sentencing practices like mandatory minimums and the three strikes laws, which we'll discuss later, are examples of how incapacitation is used to ensure public safety. So, in today's realm, most sentencing practices combine the use of incapacitation with other theories of punishment like deterrence and retribution, which can make it difficult to determine whether incapacitation is an effective tool in actually preventing crime. So for low-level offenders, research is going to indicate that the benefits of increasing public safety through the use of incapacitation are often superseded by the challenges that will come with it, with the ex-convict label in society. Think of labeling theory. So promoting some to question whether incapacitation will actually do more harm than good in the long run for certain groups of offenders. Some studies have found that prison may actually increase the likelihood of future offending. Even in the case of parole violators, research demonstrates that community-based sanctions will be more effective in preventing crime compared with the use of jail as an actual punishment. So, there is pros and cons with everything. Now we're going to discuss retribution, and this is a philosophy that reflects the idea that offenders should be punished for their bad acts purely on the basis that they violated the laws of society. So this does not take into account consideration whether the punishment will lead to a future change in the offender's behavior, like deterrence or rehabilitation. You punish someone to deter them from doing something again, or you put someone in a rehabilitative program so they correct their behavior. Here it's simply you did something wrong, so you're going to pay for it. So the theory of retribution embodies the concept of lex talionis, which is from ancient law and is even referenced in biblical texts with the discussion of punishment as an eye for an eye. So retribution is a way for offenders to pay for their harms that they have perpetrated against society. And under this philosophy, there's no justice if the offender is not punished under the law. So there is a way for offenders to pay for the harms that they have caused. Again, it doesn't focus on improving public safety, but specifically punishing the offender. And unlike other philosophies, it's not about improving, again, public safety, and it's about looking back at the act and enacting a punishment for the violation. And this key feature is often confused with many of the policies developed under the tough on crime model that dominated the late 20th century here in the U.S. So, for example, mandatory minimum sentences were developed during the modern retributive era, which began in the 70s and continues till today. So, mandatory minimum sentencing, which we'll discuss a little bit later, became very popular during the war on drugs with the passage of the Anti-Drug Abuse Act of 1986. So, one of the more notable features of the law was that it mandated a sentence of 5 years for the possession of 500 grams of powder cocaine, but at the same time, the same sentence for only 5 grams of crack cocaine. So this is a 100-to-1 sentencing disparity, which was reduced to 18-to-1 ratio with the passage of the Fair Sentencing Act in 2010. So the war on drugs has still made a significant contribution to the rise in prison population nationwide because of philosophies like this. So lastly, we have restoration. And the theory of restoration is the only punishment philosophy that places the victim at the core of all decision making. So we have 1 out of 5, in this case, placing the victim at the core of the decision making. So think of the victim's discussion and chapter that we had and how victims feel. And as you can see here, 1 out of 5, it's the minority. So the theory of restoration is reflected in restorative justice practices, which we learned about earlier in the victims chapter. So while restoration has also been positioned in opposition to the retributive model, or the model of retribution, some scholars suggest that the two may actually have some common themes, since both strive, for justice. In particular, it's important to note that a restorative philosophy does not mean that offenders are not punished for their crimes. Instead, the decision making on how the crime should be punished involves a joint process between the victim, the offenders, and the actual community. So justice becomes an opportunity for healing for the offender and the community. So research does demonstrate that victims who participate in this form of restorative justice programs generally have higher rates of satisfaction with the process compared with victims whose cases are handled through the traditional criminal courts. And this is something that we touched upon during the victims chapter as well. So now we're going to discuss determinate sentencing. So if you're a judge, right, how do you decide on a sentence for a specific offender, right? So in some cases, the law dictates what type of punishment should be handed down for a specific crime. So many jurisdictions have passed what's called determinate sentencing structures, and a determinate sentence is when the offender is sentenced to a specific term. So while the law may allow for an offender to be released early due to good time credits, these releases are incorporated into a law. So this means that there is no opportunity for an early release based on the behavior of the offender, also known as parole, which you're going to learn about later on in the course. So throughout most of history, judges have had discretion in handing out sentences to offenders. Like in most cases, judges were, free to impose just about any type of sentence from probation to incarceration. But essentially, the only guidance for decision making came from the judge's own value system and their beliefs in justice. So this created a process whereby there was no consistency in sentencing, and offenders received, dramatically different sentences for the same offenses, and the outcome depended on which judge heard the case. Was it a more strict judge or was it a more lenient judge? So this practice allowed for individualized justice based on the needs of offenders and their potential for rehabilitation, but it also left the door open for the potential of bias based on the age, race, ethnicity, the gender, and other demographics of that offender. So we have sentencing guidelines, all right, that during the 1970s, when discussing rehabilitation, right, as an effective correctional approach began um, to be looked over and was replaced with the theory of retribution. Um, there was an effort to reform these sentencing practices and to reduce the levels of discretion within the judiciary system, from take away the discretion for the judges. And many jurisdictions developed sentencing guidelines so offenders would receive similar sentences for similar crimes. Um, so at the heart of this campaign was an attempt to regulate sentencing practices and eliminate racial, gender, and class-based discrimination in the courts. So, as part of the Sentencing Reform Act of 1984, the U.S. Sentencing Commission was tasked with crafting sentencing guidelines at the federal level. Several states have also adopted sentencing guidelines as part of their determinate sentencing structure. And one of the key features of this act was the abolition of parole boards at the federal level. So, since their implementation in 1987, the federal guidelines have been criticized for being too rigid and unnecessarily harsh. So, in many cases, these criticisms reflect a growing concern that judges are now unable, to consider the unique circumstances of the crime or characteristics of the offender. So, if you see here this table, 10.1, this represents the federal sentencing guidelines, and these guidelines now take away the discretion of um, of the judges. Um, if you want to see a bigger picture of the sentencing guidelines of 10.1, it is on your Malaco text, page 225. So each federal crime is, so again, these are federal sentencing guidelines. They're not for the states, they're for federal crimes. So each federal crime is classified on the basis of its severity level and its rank on a scale of 1 to 43. So as you can see there on page 225, or up here, the first column, the offense level. Here it goes down to 27, but and that's zone C. But if you turn to page 225 in zone D, from level 28 to 43, that's going to be zone D. So the severity level and is ranked, like I said, 1 to 43. So depending on the specific circumstances of the crime and the defendant's role in the offense, this value may actually increase. So examples of these enhancements include characteristics about the victim, like was the victim a government employee or a member of law enforcement, right? So, for example, if you do one, a specific crime, but if you do that specific crime against a member of the government or someone like a police officer, then even if it's like a canine, the punishment could be more severe. So then they're gonna, aside from the characteristics, they're gonna look at the crime. Was it a regular crime or was it a hate crime? or serious human rights offense, right? And then the offender. Is there any mitigating factors and acceptance of responsibility by the actual offender? So these categories are reflected along the left side of the table. The number of prior convictions is organized into 6 categories and is listed along the top of the table that you see here in dark yellow. So to determine the sentencing range in terms of actual months, you would find the intersection of the criminal history category and the offense classification plus any enhancements. So for example, if we're going to look at aggravated assault, it's going to carry a level of 14. If a firearm was discharged during the crime, the score increases by 5 levels, so we're now at 19. If the victim sustained bodily injury as a result of the crime, the score increases by an additional 3 levels, so we're now at 22. But if the offender accepts responsibility for a crime, the score decreases by 2 levels, so we're now at a value of 20. Now, if the offender has no prior history, the sentencing range for this offense is 33 to 41 months. However, if the offender has 5 prior offenses, then the range is going to increase to anywhere from 41 to 51 months. So these are guidelines for judges to follow. It does take away, their discretion, but it does give them a little bit of discretion in the sense that there's going to be a sentencing range which they have to choose from. So they could choose, for example, in this case that we said earlier, they could choose 41 months if they want to be lenient, or 51 months if they want to be strict. But if they wanted to be any more strict, or felt that that specific offender should receive a harsher sentence, they will not have that discretion. So, of course, sentencing guidelines are not perfect, so there has been opposition to sentencing guidelines. So the U.S. Supreme Court heard the case of Blakely versus Washington. All right. So I was looking at my notes and I forgot to come here earlier. So this is the Zone D. All right, and this is the levels that we were talking about earlier. But let's discuss now Blakely versus Washington. So the court held that while the state sentencing guidelines used by the Washington state were intended to serve as a mandatory sentencing scheme, they actually violated defendant's Sixth Amendment right to a trial by jury. And Blakely states that only those facts that are either admitted by the defendant or proved beyond a reasonable doubt may be used to determine an appropriate sentence for the offender. And then we have the case of the U.S. versus Booker. And applied the ruling of the federal sentencing guidelines. So even though the guidelines now serve as an advisory practice rather than a mandatory one, research by the U.S. Sentencing Commission indicates that the majority of sentences fall within the ranges specified by these guidelines. So others will also note that the sentence severity has reduced dramatically since the Booker ruling. Now let's discuss indeterminate sentencing. So we just discussed determinate sentencing, all right? And now we're going to discuss something that's called indeterminate sentencing. And indeterminate sentencing practices generally set minimum sentence length. So the maximum sentence is reflected in the laws set forth by the legislature, though a judge may set a maximum sentence that is lower than the actual legal provision. So indeterminate sentencing was first featured during the progressive era of the late 1800s. It was during this time that new innovations in corrections like probation and parole first appeared. Indeterminate sentencing structures fit within the rehabilitative focus of this period. So the theory of indeterminate sentencing is that offenders are released based not only on their time served, but also on their efforts toward reforming their criminal selves. So as a result, the length of time that an offender serves is going to be determined by a parole board, which considers factors such as the types of programming that an offender participated in, and his or her institutional behavior and plan for reintegration in determining whether someone should be released. So the 1970s saw a shift toward determinate and mandatory sentencing structures, and many states still retain some form of indeterminate sentencing and the use of parole boards today. If you look at page 227, there's going to be a picture in which a parole board is there's a parole board hearing, and that parole board is going to provide the opportunity, for officials to assess if the inmate's rehabilitative efforts, and they're going to evaluate whether that inmate should be released from prison, right? So there are certain factors that the parole board will consider, again, like the rehabilitative efforts. Then we have mandatory sentencing. So determinate sentences were designed to limit the discretion of judges. Mandatory sentences have effectively eliminated judicial discretion from the criminal justice system completely. So under a mandatory sentencing scheme, the law prescribes a specific punishment. So earlier in this discussion, we discussed the Anti-Drug Abuse Act of 1986, which created a mandatory minimum sentence for the possession of certain illegal drugs. So Congress has also created mandatory sentencing practices for certain gun-related crimes, sexually based offenses like pornography, and white-collar crimes. So we have also seen several other examples of mandatory sentences, some of which have been declared unconstitutional by the courts. For example, the U.S. Supreme Court held that mandatory death sentences in cases of first-degree murder were unconstitutional because they did not follow, allow for a jury to weigh in on the aggravating and mitigating factors when making a sentencing recommendation. And this was in the case of Woodson versus North Carolina. So, just like there was opposition to sentencing guidelines, there has been opposition to mandatory sentences. So, one of the major criticisms of mandatory sentencing practices is that they prevent the judge from considering the unique characteristics of the offense and of the offender in handing down the actual sentence that the judge feels the offender should receive. So, in effect, the power of sentencing is shifted, to the prosecutor, who determines whether a charge that carries a mandatory sentence will be filed against an offender. So, this discretion shifted from the judge to the prosecutor. So, mandatory sentencing has been tied to a dramatic increase in prison populations throughout the late 20th and early 21st centuries, and as a result, many states have begun to repeal their mandatory sentencing laws. Um, South Carolina and Pennsylvania specifically have eliminated their use of mandatory sentences for school zone drug cases. Other states like Ohio and California have replaced mandatory prison sentences for first-time drug users with treatment programming. And the U.S. Supreme Court actually recently held that sentencing enhancements for violent felonies under the Armed Career Criminals Act are unconstitutional on the grounds that defendants were denied their right to due process and that the law was vague in its application. And this was in the case of Johnson versus the U.S. So you see here, if you see here, figure 10.2, it's going to be on page 229. I know it says up here page figure 10.3, but disregard that. So 10.2 on page 229, it's the same one up here on your screen. It's going to show the different sentencing and correction trends within different states. So unfortunately for Florida, there's no data. But if we look at a state like Texas, they're going to have implemented, or they're going to have expanded or strengthened community corrections. They're going to have also implemented risk and needs assessments, made better informed criminal justice policy, and support the reentry of offenders into the community. And this is probably going to be to reduce the prison population. So capital punishment. The capital punishment is the ultimate form of punishment. This is what's given to what are described as the worst of the worst offenders. And the United States is one of the last remaining developed countries to still use this practice. So the death penalty has been referred to, like I said earlier, as the ultimate punishment. Currently, there are 30 states, as well as the federal government and the military, that allow for the use of the death penalty. Figure 10.3 of your Malaco text, which is on page 230 or right here, shows the states that currently allow and prohibit the use of capital punishment. So, for example, if you look at Florida, we allow lethal injection and electrocution. So, a little bit of history. The first use of the death penalty in the U.S. involved the execution of Captain George Kendall in 1608 for acts of treason against the government. So, 1608. So, this was in what is the United States today, but this was when we were still a colony of England, or Great Britain, excuse me, and we were not the United States of America yet. So, since then, it's been estimated that there have been 16,000 executions over the past 4 centuries, so 400 years, and throughout history. Our system has been plagued with sentencing practices that were often disproportionate and arbitrary. And as a result of this, the U.S. Supreme Court determined in Furman versus Georgia, all right, right here in Furman versus Georgia, that the administration of the death penalty at the time constituted a cruel and unusual punishment and violated the Eighth Amendment of the Constitution. So as a result, 629 sentences in 32 states were overturned. So I'm going to retract a little bit because I saw that I skipped the history of the death penalty. So you could pause right here, give you a minute. I'm going to also return to the map so you could see some of the trends. So look at some states in the Northeast like Maine, Massachusetts, Rhode Island, Connecticut, Vermont, New Jersey, Maryland, West Virginia, Illinois, Iowa, Wisconsin, Michigan, Minnesota, North Dakota. There is no death penalty allowed there. Utah still allows firing squad. Also Alaska and Hawaii, and some of the U.S. territories like Puerto Rico, the Virgin Islands, Guam, do not allow the death penalty. But look at the trends. Right, Oklahoma also allows firing squad. So anyhow, let's continue to the legal challenges. So I discussed Furman earlier. So after the Furman decision, right, several states developed new death penalty statutes to address the constitutional violations and bring the death penalty back, to be able to be implemented. So in an attempt to resolve the issue of arbitrary administration, North Carolina and Louisiana designed laws requiring mandatory death sentences for capital crimes, and these states suggested that such laws would eliminate the unregulated discretion of the jury decision-making process that concerned the Furman court. So the justices held that mandatory death sentences would violate the fundamental respect for humanity and declared that these laws unconstitutional. However, the court approved the statutes presented in the cases of Gregg versus Georgia, Jurek versus Texas, and Profit versus Florida. So, known collectively as the Gregg decision, these cases developed a new system by which offenders could be sentenced to death, and the provisions in these cases created 3 new procedures that dramatically altered the administration of capital sentences. So first, the Gregg decision separated the guilt and sentencing decisions into 2 trials. So there is going to be, in a death penalty case, there's going to be the trial to see if someone's guilty or not, and then a trial to see if someone receives a death penalty or not. So as a result, juries must first determine whether the defendant is guilty of capital murder, and then decide in a separate trial if the convicted person should receive the death penalty. So for all states that have the death penalty, the alternate option is life without the possibility of parole, which means they serve life in prison, but they cannot be released on parole. Um, and this ultimately means that regardless of the sentence, the offender will die behind prison walls. And then second, an automatic appellate process was created that mandated the highest court of each state review all convictions of death sentences to protect against constitutional errors. So every single person who is convicted or sentenced to death does have the ability to appeal their case or the decision. So lastly, the third thing here is that states implemented guided discretion statutes to help juries with the effects of aggravating and mitigating factors in applying a death sentence. So aggravating factors are circumstances that increase the severity of the crime, such as torture, excessive violence, and premeditation. So these factors will increase the likelihood that someone will receive a death sentence. And then there's mitigating factors, which include references to the defendant's background that may explain the defendant's behavior, but they don't, constitute a legally relevant defense. So this might not excuse their behavior and allow them to be not guilty, but it might, keep a person guilty, but convince a jury that this person might not deserve the death penalty. So, in order for a death sentence to be handed out under these guided discretion statutes, a jury must determine that the value of the aggravating factors are going to outweigh any mitigating factors. So, if the value of the mitigating factors exceeds any aggravators, then we're going to go with life without the possibility of parole, or a similarly designated sentence of incarceration is going to be handed down. So, since the reinstatement of the death penalty, there have been more than 1,400 executions in the U.S. If you look at um, this figure here, it shows us um, the executions that have been carried out over the past 40 years. So this picture I have here is up to 2015. In your Malico text, page 231, it is updated up to 2018. So if you don't have your Malico text with you, so you see the last year here, 2015, there was 20 executions. Well, in 2016 there was 20, 2017 there was 23, and in 2018 there was 16. So this video was recorded in 2019, thus why there's no record of the total yet, because we are currently in December and we're not completed. The month is not, the year is not complete. So now we're going to discuss the different methods of execution under which are allowed under the Eighth Amendment. Remember, the Eighth Amendment of the U.S. Constitution um, prohibits against cruel and unusual punishment. So all of the following here: hanging, firing squad, electrocution, lethal gas, and lethal injection are allowed. So, most methods have drifted into obscurity, meaning we don't really use them anymore. Lethal injection is the primary method of execution today. And several states still do allow other methods, but they're probably going to use the more primary methods. So, for starters, we have a firing squad, and this involves strapping the offender into a chair and placing a white cloth over the offender's heart, and then 5 shooters are armed with rifles, although only 4 of the weapons are loaded with actual live ammunition. Uh, the cause of death is, dramatic blood loss as a result of the rupture of the heart and other and or the lungs. So the use of the firing squad was made famous in modern times with the execution of Gary Gilmore in 1977. The first execution following the reinstatement of the death penalty in Gregg versus Georgia. With the introduction of lethal injection in Utah in 1980, the state legislature retained the choice of firing squad in the case that the man who was going to die wanted his blood to be shed as a bid for salvation. In 2004, the Utah legislature enacted a provision that eliminated the option of the firing squad. However, Utah recently reauthorized the use of the firing squad in other methods if other methods were found to be unconstitutional. So the firing squad is also an accepted form, as I mentioned earlier, in Oklahoma, but can only be used if lethal injection is found to be unconstitutional. So then we have hanging. Like the firing squad, hanging remains a constitutionally valid method, even though many states have eliminated its use. So historically, hangings account for the majority of all executions throughout history of the U.S. Today, hanging is utilized as an option for execution in states like New Hampshire and Washington. Death by hanging is designed to occur when the offender is dropped through a trapdoor, causing the person's body to fall and his or her neck to break, and this will result in death. However, this method has seen a variety of botched executions, which will range from decapitation to strangulation. Electrocution. And during the late 1800s, electrocution was developed as a more humane option than hanging. Death occurs from a high dose of electricity over a 30-second period that is administered to the body through electrodes attached to the skull and the leg. So in some cases, multiple attempts are required to cause death, and the court upheld the use of the electric chair in the Kemmler decision in 1890, and many states have since outlawed its use, with Nebraska being the most recent state to declare the electric chair unconstitutional in 2008. 8 other states, which include Alabama, Arkansas, Florida, Kentucky, Oklahoma, South Carolina, Tennessee, and Virginia, still permit the use of electrocution under law, though no states have carried out an execution in this matter since the adoption of the lethal injection. So then we have lethal gas. Um, Lethal gas, was implemented because the public grew concerned with the potential for pain and execution methods. Several states looked toward technological advances in their search for a humane method of execution. So for many states, the move to lethal uh, cyanide, gas was the answer, and it was first introduced by the state of Nevada in 1921. And while lethal gas is still an option in Arizona, California, Missouri, Oklahoma, and Wyoming, the practice is rarely used. So in 1996, the Ninth Court of Appeals, the Ninth Circuit Court of Appeals, held in the case of Fierro versus Gomez that the use of cyanide gas was unconstitutional. And recently, Oklahoma passed legislation allowing for a lethal dose of nitrogen gas as an alternative to the lethal injection. So lastly, we have the lethal injection. It's currently the primary method of execution that is used. It was first adopted by Oklahoma in 1977. Lethal injection represents the concept of the most humane medicalized method of execution to date. Since its acceptance as a method of execution, lethal executions have accounted for the majority of all executions carried out during the modern era of the death penalty. So, the constitutionality of the use of the lethal injection has been challenged in the courts, and it does involve not only the petitions of death row inmates, but also the opinions of medical professionals. So, this challenge is based on the administration of the drugs used during the execution process, and it inquires whether the chemicals cause unnecessary pain and whether the lethal injection, the cocktail, quote unquote, masks the true levels of pain experienced by the inmate during the execution. But in 2008, the court heard the case of Bays versus Reeves, which challenged the lethal injection process in the state of Kentucky, and the court held that the use of sodium thiopental as a sedative, which is designed to render the inmate unconscious, while other drugs that stop the heart um, and lungs from functioning are administered, does not constitute cruel and unusual punishment. So that is it for this online lecture. Um, Feel free to go back. Remember, after going through this online lecture and reading the chapter, you should be able to discuss the different sentencing philosophies. Remember, there were 5. You should be able to look at the differences between the indeterminate, determinate, and mandatory sentencing guidelines that were implemented. You should be able to explain federal sentencing guidelines and how they are used, and you should be able to identify the forms of execution that are allowed under the 8th Amendment of the U.S. Constitution. So if you have any questions, remember to please bring them up in class.